Even if she joins in the middle, there will be no interruption. We'll take
No,
care of
that's okay. That's completely fine. Okay, okay. I think we would benefit if the teams could just kindly put in the chat box who the senior and the junior counsels are for the claimants and the respondents respectively, and then thereafter we'll start as per the prescribed order with the senior counsel for the claimants, and your allotted time as well, please.
Claimants can go ahead. You guys can hear us? You're on a mute, Shivam.
Yeah, I'm just typing it on the chat.
All right, all right.
Oh, I just typed the time allocation and the names of the teams with junior and the senior council for team G and LU.
Thank you, thank you. I think we can start.
Let's start.
Hello, everyone. Hebra speaking, one of the judges. Can you hear me well?
Hi, Hiba. Yes, we can hear you well.
Can you see me as well?
No,
No.
unfortunately, I think we cannot see you. I think it's the same case for you, Bijan. We can't see you.
Yeah, I cannot see her. Yeah.
Yes. I had this as well before yesterday. It's just not allowing the camera to turn on, although it's showing turned on. Anyway, I can see you, and that's great.
Perfect. We can hear you
All
clearly.
right. Yeah.
Perfect. Thank you.
Yep.
Just let me know whenever I can start.
When you be comfortable.
I'm fine. Okay. Good morning, good afternoon, and good evening, everyone sitting around the different corners of the world. I'm Shivam Agarwal, representing the team of Gujarat National Law University. Again, just confirming I'm audible and visible properly before I start my submissions.
Yes.
Greetings to the Honorable Court. May it please this court and the counsel on behalf of the claimant, which is the Artemis Astrodia in the present case, who is a passionate yoga and a YouTuber who purchased the ticket for the space yoga mat from the respondent company, and I'll be making the submissions on behalf of the claimant, who is Artemis in the case of Artemis versus Solar Time Company. During the course of my submission, I'll be making my submissions for 17 minutes and reserve 5 minutes for the rebuttals. Similarly, my co-counsel Superva Sahu will be speaking for 17 minutes and reserving 5 minutes for the rebuttals, and 1 minute we reserve for the plus minus of the overall timings. Your Honors, on behalf of the claimant, before I make the submission, I just want you to be brief with the important date sheets so that you can be aware of the situations of the fact has taken place. Initially, 15th of February 2024 was the date when the Space Yoga Mat was originally scheduled at. Then the first date and the sequence comes to the place when the 10th December 2023 is the date when my client purchased the ticket from the Solar Rim for the Space Yoga Mat. Then is the date when the 1st February 2024 is the date when my client comes to the Dubai for the 2 weeks before for the quarantine period before the Space Yoga Mat starts. Then comes the 14th of February 2024 is the date when the defendants inform that the capsule is ready to go. And it is to be noted here that during this time, even though the second wave of the COVID outbreak was already out, only one test was done and they did not have the results for the second test. So 14th February 2024 is the date when the green signal for this capsule was given, and 15th February 2024 is the day when the capsule kicked off. And it is to be noted that during this 2 weeks of period between 1st February 2024 and 15th of February 2024 is the date when the quarantine period was made applicable to the all the participants, which are 9 participants, including my client. So this was the brief date sheet about the facts that has happened and has taken place in the present case. If I move to my arguments, Your Honors, on behalf of the claimant, I would like to make my submissions in such a way that the duty of care towards my client was breached by the defendant, which is already outlined in the agreement they have agreed, as the defendant was negligent in one, non-fulfillment of the clause 7.2 of the agreement; two, non-fulfillment of the UAE spaceflight regulations and health standards; three, non-fulfillment of Article 21 of the Law of Obligation, DIFC Law number 5 of 2005, which is reasonable care. If I make submissions for the first point, where the uh, defendant he has breached the duty of care under agreement, which is agreement 7.2. Agreement 7.2 is the is space flight operator safety protocols, so that the Solar Dream, the defendant, shall ensure compliance with the safety requirements under the applicable laws. This clause establishes a duty of care beyond legal compliances, requiring the Solar Dream to take the proactive measures for the passenger safety. One, here it can be noted that the proactive measures were not taken by the defendant tourism flight company. In the present case, one, they did not wait for the PCR results. Even during the period of the quarantine, when 2 weeks of quarantine was taking place at the place of the defendant, the report or the test for the COVID were not taken, even though the COVID outbreak was already out. So this clause 7.2, which outlines the operator should ensure the compliances for the safety of the passengers, it was not fulfilled. Second,
Counsel,
Your
you're
Honor.
you're arguing that the compliance with the space flight activities and regulations wasn't carried out properly. But what part of these regulations
Yes,
mandates that the operator must have ensured or must have waited for the RT-PCR test results to come through?
correct. Your Lordship, Your Honors, if I may bring your Honor's attention to the clause of 4.4.4, which is health stabilization and medical planning. The clause reads as implement procedures and process to prevent acute infectious diseases from being manifested during the flight, such as through quarantine and social isolation of flight crew and special flight participants, identify specific type of medical conditions that could result in ending the flight early, and identify the medical criteria for checking due to the illness or medical emergencies. So this clause 4.4.4 of the recommended practices for human spaceflight occupant safety already reads about then when there is a situations of the infectious acute diseases, the defendant in the present case needs to fulfill all those duties, which prevents the participants safety, which does not hamper the participant safety. So it is again submitted that it was the defendant who was negligent in following the clause 7.2 of the agreement, which again mandates them to follow the recommended practice for human spaceflight occupant safety, which was in the present case, as per my submission, not followed.
All right.
Counsel, I also had a question.
Your Honor.
So your client had chronic headaches for a number of years,
Your Honor.
and in fear of not being able to come onto the space flight, your client concealed that symptom. Now, it is listed as one of the symptoms of this particular variant, which is a new variant in itself. A
Yeah.
lot of things are uncertain. Would you not agree with me when I say that had your client disclosed that symptom rather than intentionally concealing it, there was a possibility of perhaps the variant being detected?
Your Honor, I would like to make this submission into three links. One, that it was not the headache which led to the COVID. Headache was consistent since last 5 years, and it has become the part and parcel of her life, which happened for the past 5 years, and it was so tolerable that Hence, she could not consider it as the illness, but she just considered it as the
But
inconvenience.
how can we prove that headache had no correlation to the COVID?
Because in the fact of the sheet it is very clear that the new variant was determined before 5 to 10 days of the 5 to 10 days of the results. 5 to 10 days when I'm infected, during the 5 to 10 days I'll be getting the COVID, but she was having the headache since last 5 years. She came to the quarantine place 14 days before, and during those
Kanchan, I think you did not get my point. What I was asking is,
correct.
I agree that she was having headache for the past 5 years, and let us assume that it is for a particular reason. Now, the headache that happened during your pre-tests, the first set of tests which were conducted, was it your client's own judgment that this headache is just a result of my 5 year long illness or whatsoever the case may be, and not COVID?
Yes, because she has been suffering from this headache for last 5 years. So she assumed that this is just the normal day. This is just another day where she's suffering the headache from. And she did not treat it as the illness, or she did not treat it as the COVID, but she just treated it as the normal day. Had it been the situation that there are other symptoms, she might have disclosed it. But she was just feeling the normal headache, which she usually feels so. So she
Okay,
did
so
No,
not,
but
so you have essentially,
can't.
yes, yes.
Yeah.
Your Honor.
So I'm sorry to cut you out, and sorry, Aditya, but um, in the facts it says in the second week she began to suffer from severe headaches, which were not normal. The dull head she has had dull headaches throughout her life, but from the second week in the quarantine, if you refer to para 9 of the problem, it says in the second week it did get worse, and the fact of which wasn't disclosed
Your
to the
Honor,
medical team.
again to make the submission for this point, I would like to refer clause 5.2 of the agreement, which says that the passengers declares and represent that to the best of their knowledge and belief, they are not aware of any medical conditions or symptoms of a potential medical condition. Now, this is to be emphasized that may affect their fitness to participate in the space flight. So my point here is to make is that the abnormal headache in the second week also was considered by her that this will not affect their fitness to participate in the space flight. So she considered that this is another day where the headache.
Also, this clause does not help you at all. This is talking about prior to entry into the agreement. We are talking about a completely separate situation over here where a medical contingency is arisen, and you've been asked to provide certain information so that the test results can be accurate, and the information was concealed.
then then again the 5.3 clause helps him, because if your honor says that the medical conditions changed during the quarantine period, that the headache was severe now, then the clause 5.3 says that if there are any medical conditions which changes during the period of the agreement and after before the flight takes off, then if that affect their fitness for the travel. So according to my client, the change in the medical condition, that the severity of the headache, the increase in the headache, did not affect the fitness for the space travel.
Okay,
Although she
Consul,
thought that,
I've noted your submission in this regard. Just one last short question.
Your Honor,
Was your client made aware that the PCR test results are not out, and there could potentially be a risk because the results are statistically improbable but not impossible?
so to answer this, according to paragraph number 12, lateral flow test was done, and the Artemis and the other passengers were given standard last time minute instruction in case of emergency. So my client was taken the blood sample for the PCR test and the lateral flow test also. But even without the results of the PCR test, only on the suggestions of the nurse, who is even not qualified even to give the suggestion, and who is even not qualified enough to go undergo the medical checkup, the capsule took off. So my client was not aware of the results of the PCR test. It was against my client's it was against my client's will. The flight took off, and had it been the situation that the PCR test is positive, the flight might have cancelled, or the flight might have not.
Noted, Consul. I'll just remind you, we are 12 minutes down. You have a few minutes left, so please continue.
Yeah. So one is the 7.2 agreement, duty of care under the agreement, and Article 21 of the law of obligation, DIFC number 5, again defines the reasonable care as the person of ordinary skill would exercise in similar circumstances, considering the probability and severity of the potential harm. So again, to make the submission, the reasonable care by the defendant was not taken in the present case, as the PCR test results were not awaited. Second, the medical examination and the medical evaluation was not done by the qualified medical professional. It was done by a mere nurse who was even hired from the 10 years of experience from a private hospital, and she's not even a permanent qualified medical doctor, which took the second medical examination, which she is not supposed to do from. The next submission I would like to make is that to define the negligence, I would like to cite a case of Cotton versus Commissioner for road transport and transmit. It is the negligence is the failure of a person to take reasonable care, which failure causes the damage to the another. So this situation where the defendant did not take the reasonable care led to the damage to the plaintiff in this case, the client in this case. And to determine whether a person has been negligent, there are certain tests which were defined in the case of Maclean versus Stedman. I would like to cite all the four tests and match with the present case. The one that the probability that the harm would occur if the care was not taken. So had it been a
Council,
situation that the care has already been taken, had it been,
while
sorry.
you're doing that, I would just request you to also link it to the sum that you have claimed, because this is not loss of earnings for any personal injury or death or disablement. This is essentially a loss of earnings for your video going to a subscriber, and sort of getting some revenue out of it. I want you to convince me that the defendant or the respondent had any obligation to take into consideration, and therefore in breach of that obligation is liable to pay you the said amount which you have claimed.
Your Honors, although the damages part would be covered by my co-counsel, but if Your Honors are asking me to divide the sums,
No, if that is the case, then it's okay. You can continue.
yeah. So, four tests to determine whether the present case is the negligent of doing is not. The likely seriousness of the harm. This was the very serious case where the spacecraft was taken to the space. Had it been a situation that the negligence has not taken place, the harm would not have occurred. The burden of taking precautions to avoid a harm. The burden of taking precautions was on the
Also,
defendant.
again, what is the harm that we are talking about? What is that exact harm? Is it the loss of revenue, which is the harm?
One, yeah.
So that is why I was just just link it to the claim.
So one harm is that the spacecraft came in between, the space tour was not complete. Second, the harm to the personal harm to which she has suffered from. Third is the revenue harm again, which she could have earned from the YouTube. And these are the three harms I can define right now. One is the incomplete journey. Second is the personal harm, and the third is the revenue harm which she suffered from.
So
Okay,
one
Cons.
quick question.
Yeah.
Sorry.
Yeah, yeah. So I hear your argument is that there was a negligence, duty of care, but would you not also accept that under the contract law, DIFC contract law, you had also had an obligation to mitigate the harm, right? And which was informed that if if the claimant had a medical condition, now it is not left to claimant's subjectivity that whether it is going to impact the fitness for a space travel or not, but you had all the reason to inform, disclose, and mitigate the potential harm that could have caused, right? So, at section 117 of the contract law casts a very clear obligation. How do you negate that?
Your Honors, with regards to the mitigation of the harm which my client would have done, is the case. My submission is that the headache was not the reason for the COVID-19 which I suffered from. It was the Solar Dreams protocols which were grossly inadequate. Had it been the situation that they might have waited for one more day for the PCR test, this situation might not have arrived. So it is not that the headache which has led to this situation, but it is the gross inadequate services which have been provided by the Solar Dream and the negligence they have been taking place for the medical reports which they did not wait for it.
But in Solar Dream's case would be that it was a forced measure. It was a epidemic, pandemic, not within their control. So
Even
why are they failing, or why are they grossly negligent?
but waiting for 1 day for the PCR result was completely in their hands. Even though it is a force measure and it is not there, it is not in their hands. But when they could do the test, they could have waited for the results of the test, and it was
Council,
Okay.
yeah.
I'll just remind you that you have exhausted your time. You can continue, but that time would be deducted from your rebuttals.
Your Honors, I would like to submit my arguments and submit that the defendant in the present case has breached the clause 7.1 and 7.2 and also was negligent with the services they have provided. Henceforth, my client is not responsible and the defendant was responsible enough for the situations. And I submit my arguments here. Thank you.
Thank you.
Hello, am I audible?
Yes, you're audible.
Good afternoon, everyone. Greetings to the Honorable Court. I'm Gausia, and I shall be the senior defendant representing the company, Solar Dream, in this particular case. I shall be dealing with ground one regarding the liability of the defendant in tort and breach of contract for 17 minutes, and my co-counsel Fahima shall be arguing the counterclaim for 17 minutes. Your Honor, the counsel seeks permission to begin with the arguments. Before I begin with the arguments, would you like to have a brief summary of essential facts?
I think that should be fine unless I would ask Vision to advise on that, and I would also just confirm you're the team from Amity, right?
Yes, Your
Okay.
Honor.
So yes, yes. I think the
I
facts.
think we can move to the arguments. Facts, it's fine. Yeah.
Okay, sir. For the sake of convenience, I have divided my arguments into four legs. Uh, the council respectfully submits before this honorable court that Solar Dream is not liable to Ms. Artemis in tort or breach of contract. Solar Dream has rigorously adhered to all the applicable health and safety standards as evident from the facts of this case. The decision to utilize lateral flow tests, conducting pre-flight medical examinations, quarantine protocols, and also the requirement for all the passengers to disclose any existing health conditions in the spaceflight agreement itself were in line with the prevailing medical advice and the situation.
Counsel,
To
can that advice really be called a medical advice when you've taken that from a nurse who has said that it is statistically improbable? What the way I see it is that there were certain corners which were cut. The reason being is commercial feasibility, which was a commercial decision on your part, which led to the present situation, which was also in dereliction of your both contractual duties and a certain duty of care which you owe to the passengers in a venture of such a nature. How would you respond to
Yes,
that?
yes, Your Lordship. But however, there was a very limited time period. They were restrained by a meteorological window, and they had to operate the space flight during that time. And it was provided by my client in the space flight
So,
agreement.
Counsel, are you admitting that this was a commercial decision made by the company to to continue with the flight despite the PCR test results being awaited because that was the only window you had to launch the meteorological flight, and if not, then you could have potentially have had to refund the amount back to the passengers.
Your Lordship, I think the decision made by my client was a reasonable decision, which a person as a company taking care of the interest of all the passengers and the company themselves, they've taken this decision and they've provided in the agreement clauses as well that there are many inherent risks involved in a space flight tourism, and they tried to do what is in the best interest for everyone at that point of time, and they had taken all the essential protocols, they had followed all the essential standards which were necessary during that time to mitigate all sorts of risks.
Continue.
Council, this seems to be at odds with the human spaceflight regulations in UAE, right? While they're trying to adhere to the contract and try and chase the flight window, but definitely the safety of the passengers, which is a fundamental obligations for the operator under the regulation, was kind of overlooked. So contractual compliance is one thing, but then your client will end up breaching regulation and face penalties for that and probably prosecution.
Your Lordship, I would like to differ. As per the human Human Spaceflight Activities Regulations of the UAE 2022 and Article 6 has provided certain clauses in which it mentions about the necessary standards and safety protocols. And in all, my client has taken care of all these protocols provided, like for example, informing all the spaceflight participants in writing about the risks and informing about all the unknown risks as well as known risks, and all the protocols were authorized and all the mechanisms were taken into consideration. There was a written approval, there was a written consent of all the participants, and also they complied with all the provisions of Article 6 of this regulation.
So are you saying that merely by informing the passengers of the space flight about the inherent risk, which Article 6 mentions, and I'm well aware of that, that's enough, right? The passengers are not subject matter experts. They are just ordinary, passengers who are able to afford this ticket, but they do not well understand the risk involved in the space travel, whether it's technical, mechanical, biological, health and safety, right? So by just getting somebody to write off on a consent, they would probably not understand what are they consenting to. So you had a bigger owner's responsibility to make a better decision and not just chase a small window and use a nurse to get a medical sign off on that. What do you say to that?
Your Lordship, all the passengers had signed the agreement knowingly and had read all the clauses. And not only the agreement, like apart from the agreement, they have taken all the necessary safety measures, and everyone was aware of the situation. And the passengers boarded the flight on their own risk and in their own understanding that there was a risk of COVID, but the quarantine measures were all in place. There were there was one medical evaluation done right after the purchase of the space flight, and there was one medical examination done right before the space flight as well. However, the claimant did not disclose certain material facts about her chronic headaches, which had caused all these
Also,
issues.
what are the chances that her concealment of the facts would have resulted in the negative COVID test report, the variant test report? I mean, the way I see it is, for all intents and purposes, one, the symptoms are there are n number of symptoms. When you're looking at n number of symptoms, and if only one symptom is occurring, the chances of it relating even remotely to the COVID and thereby impacting the results. That, I mean, what is the connection? I just, please help me with the connection with the
Yes,
non-disclosure and the.
yes, Your Lordship. Even, okay, hypothetically speaking, if suppose the claimant's non-disclosure would not affect the situation at all, however, still she had a duty to disclose, because in the agreement it was clearly stated that you are supposed to provide all your medical
Also,
history.
granted,
And
I granted, claimant had a duty of disclose and claimant did not disclose. What I'm asking you is, could you please link it? Because I'm trying to understand from the perspective of the relevance to your claim, your
yes,
claim, sorry, and as well
yes,
as your defense. Please link the non-disclosure to either your counterclaim or the defense. What's the purpose behind this bringing out the non-disclosure?
Your Lordship, this would be dealt in detail with my co-counsel, as her counterclaim is about breach of contract by the claimant. But however, if you would still like, I would
No,
I would
that's
answer
okay.
this
That's
question.
okay. Proceed.
The Council would like to humbly submit before this Honorable Court that Solar Dream did not act negligently. Solar Dream, as a spaceflight company, has a paramount duty to ensure the safety of its passengers, and in accordance with this duty, Solar Dream diligently implemented comprehensive health protocols aimed at mitigating the risk of COVID-19. And the health measures implemented were substantial and aligned with best practices at the time. The unexpected COVID-19 outbreak aboard the vessel is not due to negligence, but an inherent risk of pandemic conditions despite stringent precautions. Solar Dream fulfilled its contractual duties by rigorously implementing necessary safety protocols. The swift spread of the virus highlights its unpredictability, not negligence on the company's part. As provided in the Moot proposition in page 9 of the Moot Court bundle. Moreover, Your Honor, I would like to refer to the
Counsel,
case of Bolton
counsel,
versus.
it was not unpredictability. It was your client did not want to wait for the RT-PCR results, and then they had a nurse instead of they had a doctor working with them who was from NASA, right? Dr. Leonara McCoy, who for some reason is not available on the day of flight. Uh, but so it was not unpredictable. It was your client avoiding what was obvious and making sure that the flight takes off so that they can wash their hands off that yes, flight has taken off. Now they are at their own risk. So I how do you convince me that it was unpredictable?
Your Lordship, about the specialists, it's not mentioned in the Moot proposition. We are not aware about any of the specialist doctor which was there in the picture at that point.
It is it was in circulated via clarification where they says a doctor from Dr. Leonara McCoy, who was retired chief medical officer of NASA, was working with Solar Dream. Anyway, move on. Yeah, you can
Okay.
carry on,
Secondly,
counselor.
the council would like to refer to the case of Bolton versus Stone, where the court emphasized the need for reasonable precautions while recognizing that not all accidents can be prevented. And the council would like to respectfully submit that Solar Dream has adhered to the general standards of duty of care, has, as I had previously highlighted, that all the safety measures were taken, putting the best efforts to ensure the safety of all the passengers by taking quarantine measures, conducting medical examination, lateral flow tests before the spaceflight took off. And the standard of care is ensured by comparing the conduct of the defendant under identical circumstances with that of a hypothetical reasonable person. Like, would a reasonable person in the same situation as the defendant do the same thing? In
Also, the prudent and reasonable spaceflight operator standard is rather the standard I think would be appropriate for this case. However, this venture is such that it is one of a kind. So how do we come to the relevant duty of care standards to determine whether or not you have breached it?
Your Lordship, we would consider if the all the measures taken by Solar Dream is are the same which a reasonable person would do in the same situation, in the same circumstance. Like in
Yes,
the case
and
of
who would be the reasonable person in the same situation in the same circumstance?
any reasonable person. It can be me, it can be you. If we are in the same situation, same circumstance, if suppose I was the operator of the company Solar Dream, what would I do in that situation to keep in mind all interest of the passenger as well as the company? And this is my contention that they have taken all reasonable measures and they've acted reasonably in this case, and hence they were not negligent.
Counsel, are you aware of section 18 of the law of obligation, article 18 of law of obligation, duty of care? And do you think what you are arguing kind of is in line with the ingredients of duty of care set out in DIFC law of obligation?
Yes, Your Lordship. I have referred to Section 21 as well, which speaks about the standard of care. And in order to establish a breach of duty of care, the claimant has to prove that the defendant has failed to exercise even the smallest reasonable measures, and like having taking in regard of the seriousness of the situation. And reasonable care means the care which a person of ordinary care and skill engaged in that type of activity would have exercised. And the standard varies for in different situations and circumstances as per the
Right.
DIFC law of obligations.
Correct. That is section 21. I'm referring
Yes.
to section 18 where it says whether the cause is foreseeable to the acts or omissions, which can lead to the loss. Now, that's one of the requirements. So, as a space flight operator, which ought to have known the risk involved, it was very obvious and foreseeable that ignoring a safety risk in the middle of a pandemic or towards the end of pandemic would cause disruptions and lead to loss. So, can you address Article 18, duty of care, not 21?
Yes, Your Lordship.
Counsel, just to be clear, the ask here is to address the elements of the tort claim and how you challenge that, which is based on Article 18.
Your Lordship,
Yes.
yes. As per Article 18 of which speaks about what is duty of care and if it was reasonably foreseeable, and if it was fair and just and reasonable, I would like to contend that even though all the safety measures were taken into place and all the company had taken all the measures to make sure that such a situation may not arise, and even if it does, like what they could do for all of that. So I feel like they have upheld the duty of care.
All right, move on.
Thank you, Counsel.
Solar Dream fulfilled its legal and industry obligations for space travel safety, thereby exercising a reasonable duty of care under the circumstance. This responsibility is in line with the emergency actions conducted during the flight after learning of the positive COVID test result. Thirdly, the Council would like to submit that there was a fundamental change in circumstances. Solar Dream's premature landing was deemed necessary due to the uncontrollable COVID outbreak among the passengers and the crew in the space flight. Solar Dream cannot be held liable for the claimant's inability to utilize amenities or film videos due to her own health issues, as Solar Dream continued to prioritize the safety and interests of all passengers under these changed circumstances. The COVID-19 crisis, as an exceptional circumstance, may affect contractual obligations by hindering parties' ability to fully or timely comply. The law mandates that parties undertake all reasonable efforts to overcome any impediments to ensure best efforts at compliance with agreement or to adapt to swiftly changing circumstances. As per Article 7.1.7 of the Unit Principles, as highlighted in page 55 of the Moot Code bundle, and I quote, non-performance by a party is excused if that party proves that the non-performance was due to an impediment beyond its control and that it could not reasonably be expected to have taken the impediment into account at the time of the conclusion of the contract or to have avoided or overcome it in the consequence. Article 7.17 provides legal justification for excusing non-performance due to this unforeseen fundamental change in circumstances which were beyond Solar Dream's control. The law mandates that parties undertake all reasonable efforts to overcome such obstacles, and which Solar Dream has done. The claimant getting infected by the virus and being unable to film videos or the spread of COVID infection in the spaceflight cannot be attributed to Solar Dream since it was beyond the company's control. Lastly, I would like to assert that there was a voluntary assumption of risk on behalf of the claimant. As per Section 55 of the DIFC Law of Obligations, and I quote, a defendant is not liable to the claimant under Chapter 2 of this part, which speaks about negligence, if the claimant has knowingly subjected himself or herself to the risk on which the claim is based, and B, the claimant wishes to subject himself to that risk or agrees to subject himself to that risk. I would like to refer your lordships to the case of Murphy versus Steeplechase Amusement Co. in the year 1929, the doctrine of voluntary non-fit injuria, which speaks about cases where an individual voluntarily engages in an activity with inherent risk, was applied to exempt liability of the defendant. Voluntary non-fit injuria is a legal principle that translates as to one who is willing, no harm is done. It obligates.
Council, I'll just remind you that you've exceeded your time. It's 18 minutes, and whatever additional time you take would be deducted from your rebuttals and self-defense.
Okay, Your Lordship, I would just conclude my argument.
That's
I would
fine.
like
If you would like to continue, it's fine. Just note if you need time for rebuttal, just keep that in mind.
Okay. It operates, voluntary non-fit injury operates as a defense in negligence cases where the plaintiff voluntarily assumes the risk associated with any activity, thereby absolving the defendant of liability. Like in this case, the claimant knew the risk of boarding a spaceflight during COVID situations and the risk involved in her concealing the fact about her headaches, which had got severe by the time she boarded the spaceflight, and all these factors constitute her knowing the risk and still willingly boarding the space flight. So, to conclude my argument, the Council humbly requests the Honorable Court to hold that Solar Dream is not liable to the claimant for negligence or breach of contract. It was an honor arguing in the Court of Law. Much obliged.
Thank you.
Thank you, Counsel.
With your Honor's permission, I may move ahead with the rebuttals.
Please go ahead.
Uh, with regards to the submissions made by the counsels for the defendant, I have 4 points to be made in the rebuttal rounds. One, just for the commercial interest, how is not waiting for 1 hour of the launch is in interest of the overall interest of the passengers? The wait, only the PCR results were declared just after the 1 hour of the launch. So how is that in the interest of the other passengers? Second, unqualified nurse has done the medical examinations. So what is the responsibility of the defendant in that case? Third, why was no PCR or the floor test was done during the 2 weeks of the quarantine? Why was it the last day of the quarantine when the report test was done? Fourth is, how does the defendant assume that the claimant did not come into the contact of the COVID during the period of COVID-19, because the symptoms which come into the role is 5 to 10 days, and it was the last day when it was the second week when she has come into the problem of the severe headache. So it can be the situation the claimant has come into the contact in COVID during the quarantine period only. So how do you answer that? How do you defend that the COVID-19 was not come into the contact during the quarantine period? So that's all for the rebuttals.
I hope the counsel for the defendant has noted down the points, and please feel free if there is any if you have not if you have missed any point, because I understand it went very fast. So feel free to ask, and yeah, you can continue.
Your Lordship, I would like to say that the claimant, the senior claimant, has mentioned about that the defendant could have waited for an hour for the PCR results. However, as per the facts of the case, it's given that there were delays at the lab. And how would the defendant have known that they would get the results within 1 hour of them boarding the space flight? It was all uncertain. They had no idea when they would get the results, and it was clearly mentioned that there were delays in the lab, and it was not under the control of the defendant. And also the fact about why couldn't they do the PCR test before 2 weeks. The PCR test, as it's not mentioned in the facts about how the PCR test should be done or what is the right method. And however, the company did take all the essential safety protocols and the measures by making all the passengers quarantine for 2 weeks and then doing a medical evaluation after that and then a lateral flow test. And they couldn't get the PCR results due to delays at the lab. And it was they were given a green flag because according to statistics, the lateral flow tests are enough to avoid any major risk. And that's all, Your Lordship.
Counsel, I'm sorry, I know it's rebuttal and rebuttal, but you did mention that according to the statistics, lateral flow tests are enough. Is that coming from the fact sheet here, or is that, do you have an authority? I just want to understand where that is coming from, because you're citing to substantiate your claim
Yes, Your
around the
Lordship,
defense.
I would like to refer to page, just 1 minute.
It is paragraph number 12 of the Moot preposition, where the advice of the nurse was that statistically it is enough. However, it is not statistically, but it was the advice of the nurse which says that it is statistically proven.
Counsel for the defendant, is that your position as well, or you can move on if you we can it's, we can record that it's not clear at this point, but I was curious.
Yes, Your Lordship, I'm done with those rebuttals.
Okay.
Am I audible?
Yes.
So can I start?
Yeah, please.
So should I start? I'm the claimant from GNL.
Yeah.
Yes, you can start with the counterclaim.
Good afternoon. I'd like to ask, am I audible and visible?
Yes, clearly.
This is the team for Gujarat National Law University stating from the side of claimant to state just we will we would like to argue on the points. For issue 2, we would be dealing with how Ms. Ashrotia is not liable to Solar Dream for the breach of contract. To support this argument, I'll be taking the next 17 minutes and reserving 5 minutes for the rebuttals. The counsel shall be presenting with the main 4 arguments. First one, that the non-disclosure of headaches by Ms. Ashrotia does not constitute as a breach of contract, as they fall outside the scope of the conditions as mentioned in the space flight agreement. Second, that Solar Dream's reputational loss stemmed due to the lack of safety protocols, and Artemis cannot be made liable for the same. Third, that Artemis acted in good faith and cannot be said liable. Fourth, that the claimant cannot be held responsible for the reputational loss as losses occurred due to Solar Dream's own conduct. If there are no preliminary questions, I'd like to begin with the arguments.
Yes, please. Before that, I recall your co-counsel had mentioned had asked a question with respect to what is the harm.
Yes.
Yes, because I'm trying to link your claim to whatever you're saying. So my question was, why would the company have any obligation to look at your YouTube subscribers, or what loss of income or what loss of revenue? This is not loss of revenue for personal injury, disablement, death. Why would company have an obligation to look at the lost opportunity and thereby award you pay to you a certain amount?
Yeah, much obliged. So, for the 15 million damages that we claimed, the 7.5 million is consisting of the payment we did for the space flight agreement. This is stated in the clarification. Rest 7.5 million are for the damages. And in this regard, there are first in the clause 4.5, in case of gross negligence, there should not be the criteria of 1 million can be refused, and we can ask for a lateral payment for all the damages that are occurred for us. First is the loss of reputation that Artemis, my client in this case, considered, because after the consideration from Solar Dream's own agent, we got to know of all the things, and he represented that the gravitational force and everything that would happen in the space flight. Due to that, only that Artemis considered buying such a ticket of an expensive price amount. This means that Artemis, in her own mind, knew that the space flight would help her in even in her health term as well in her own.
No, Counsel, my simple question is why should the company be bothered about what Artemis may want or did not want? I'm just looking at the terms of the contract, and why should I be bothered at all?
Because Solar Dream in this case failed to consider all the things that he represented. The
No,
Solar
but
Dream
I'll
yes.
point you to, I think there is an entire agreement clause if I'm not wrong.
Yes.
I'll point you to clause 9.1.
Uh, in addition to all the reputational losses, Artemis also suffered an injury in reference to the COVID outbreak also. Previous to this, we are stating that Artemis contracted COVID-19 during the quarantine period, that is needed to be determined by the defendants in this case. But Since Artemis
Okay, so
contracted,
council will just segregate it. One is your remedy in contract, one is your remedy in tort.
yes.
Now, for your remedy in tort, all I'm asking is to just have a connection drawn to your claim as to why Artemis should say that for whatever loss of income that has happened, the company should be liable.
Those are
I'm
two.
sorry. Just a quick note. Suprabha, you represent the claimant,
Yes, ma'am.
right? But now it's actually according to the agenda, it should be the counterclaim first before
Yes,
defense to counterclaim.
ma'am. Yes, ma'am. For the counterclaim in our previous rounds that happened yesterday, first the claimant spoke. That's why. Should
Okay.
I?
No, I'm just looking at the agenda. Let me just double check the agenda. So yes, so now it should be a junior defendant counterclaim and then
Okay.
junior claimant defense to counterclaim.
Oh, ma'am, should I continue or let the other side speak
No,
first?
I think we should let the other side speak first, so then you have an opportunity to respond to their own submissions.
Okay, ma'am, that works.
Thank you.
Am I audible?
Yes.
So, greetings to the bench. This is Junior Counsel Zenith Fahima, and I shall be dealing with the counterclaim. The second contention is concerning Ms. Astrothea's liability to Solar Dream for breach of contract. For the convenience of the court, the contention has been divided into two legs of argument. Firstly, non-performance of clauses. Non-performance is defined under Section 70 of the Contract Act 2004 as a failure by a party to perform any one or more of its obligations under the contract, including defective or late performance. In the present case, Ms. Astrothea herself has admitted to the fact that she has not complied with the agreement, specifically clauses 5.2, 5.3, and 5.4, and by not providing complete information about her health condition and willfully withholding information with the intention of deceiving the spaceflight operators.
Council, just to question, how does that relate to the counterclaim?
Um,
The
Not sure.
non-disclosure by the claimant, how does that
Yeah,
relate to your counterclaim?
yeah. Non-performance of the contract is a breach of contract.
So,
The I think the point here is causation question. So your claim for damages based on the breach of contract, which breach exactly have caused the particular damage that you're claiming?
Non-performance of the contract according to Section 70 of the DIFC contract law.
Okay, and you mentioned the failure to disclose, right?
Apologies, can you repeat?
In terms of non-performance, failure to disclose, is that right?
Yes.
Okay, all right. Thank you. Please proceed.
And clause 5.2 in the agreement states that the passenger declares and represents to the best of their knowledge and belief that they are not aware of any medical conditions or symptoms, that the passenger understands the importance of providing accurate and complete information. In the present case, Ms. Astrothea has not fulfilled her part of the contract by not declaring her chronic headaches to the spaceflight operators. As mentioned in the Moot problem, paragraph 9, Artemis was contacted by the employees of Solar Dream and was told that she had to carry out an evaluation before she could board the flight. Even during this time, Ms. Artemis had made no mention of her chronic headaches to the medical professionals. This is vital information that was withheld from Solar Dream. Clause 5.3 states that the passenger undertakes the responsibility to inform the space flight operators if there is a change in a medical condition or if they become aware of any medical condition, and this clause includes the time period between the first medical evaluation and the right before the launch scheduled launch date. In the instant case, Ms. Astrothea's condition worsened during the second week of quarantine, and yet she did not inform Solar Dreams about her changing medical conditions, nor when we had a medical evaluation with the nurse right before the launch did she mention it to her. This is highlighted in para 9 of the Moot problem. The concealment of this fact amounts to non performance of the contract. Clause 5.5 states that the passenger is responsible for informing about any medical changes, and this change might affect their eligibility to fly in the spacecraft. In the first place, Ms. Astrothia did not mention about her chronic headaches. In addition to this, she did not even mention about her debilitating headaches that resurfaced prior to the launch. Her actions clearly intended an attempt to hide the material facts, that is, her chronic headaches, as she was scared that she would not fall short of the eligibility criteria, as intended three times in the paragraph, in three times in the mode problem.
Coun-
First in the
Counsel, counsel, it is claimant's case that yes, there was a non-disclosure of the medical condition. However, it was in the belief that that condition will not affect the ability to, board the flight, right? To carry out this uh, space flight. So the obligations in 5.1 to, Article 5 of the agreement are subjective, and to some extent it appears that the intention was to leave it to the discretion of the passenger to decide whether that condition will affect or not. But as an operator, so I have two questions. So claimant's case is that there was a condition, but that is not going to affect the travel. That is number one. So how do you rebut that? Number two, which is related to one as well, is as an operator of the flight, did you not have a responsibility to carry out your own examination slash due diligence to ensure that there is nothing which is whether latent or patent in medical conditions that prevents the flight or puts anybody else at the risk? So can you address these two points?
yes, Your Lordship. 1 minute. Your Lordship, her headaches, especially now that considering headaches are are a symptom of COVID, her debilitating headaches, she should have informed that this change has happened. So then uh, so that the Solar Dream could have taken the required steps necessary to accommodate her needs. If she had talked about her chronic headaches before itself to the medical professionals when doing the medical evaluation itself, uh, they could have done they could have taken a unique approach to her, and they could have done certain specific things or protocols that was required for her because she has this certain condition. Because because Solarin was not even aware of certain chronic headaches, they took the best decision that they could with the available information to them.
Okay, just quick clarification. Like the assumption is that passengers will not disclose for whatever interest, right? They will not disclose things that would eventually affect not only their experience in the space retreat, but also expose others, and which eventually happened in this case, right? So, as an operator, assume that the passengers are not going to disclose. What have you do, or what duty you had, what the duty of care you had as an operator to perform towards the remaining passengers, not just Miss Artemis, but towards other passenger that all hidden conditions are also looked into or tested upon.
Your Lordship, firstly, through the contract, it is mentioned 5.5 clearly that they are responsible for it. So it doesn't, we cannot assume that they are trying to hide something, because clearly they have signed this contract. So that means they are going to be responsible and that they understand how important it is to provide accurate information. Moreover, in the space industry regulations 2021, in clause 70, subclause subclause 5, it is mentioned that the medical assessment will be based on the evaluation of the individual's medical history and medical examination and medical tests. So here, when one aspect, which is her chronic headaches, which is what a big part of her medical history, is not mentioned to the medical professionals of Solar Dream, it can be very hard to assess her situation completely.
Council, just a follow-up on that before you continue. You mentioned it can severely impact. I just remember there being a list of symptoms, which are the common symptoms and the uncommon symptoms. And the list runs down to, I think, well over a dozen symptoms. It is not the case that there were more than one symptom, if I'm not wrong. There's only one symptom, which is headache, which had been continuing for a very long period of time. So, just wanted to confirm and just wanted you to justify what you just said with respect to non-disclosure of a headache being so critical so as to affect the proper evaluation by your medical professionals.
Uh, yes, Your Lordship, because these medical evaluations that is taken is based on their past medical history, and that is why she was asked in
No,
the
but
mood problem.
the test is not the COVID test. Is it basis your past medical history?
Sorry, can you
The
repeat, please?
test which was performed prior to the PCR test, was that basis the past medical history?
Yes, Your Lordship, it was past. She was asked for her past ailments and a medical log. So the medical
No, she was
evaluation,
asked for it, but what I'm asking is how would it impact the test results?
because the test that is taken now for to check the eligibility if they're able to go to this go to space is based on their past medical experiences. This evaluation, the past heavily impacts the present evaluation that is happening.
No, I'm sorry, I may be a little lost here. Just help me with which test are we talking about? The test required to check the eligibility, or the test of the variant, whether or not you're infected?
Uh, the eligibility.
No, but then the eligibility test, if you're talking about the eligibility test, council, how are you seeking compensation for whether or not the person was eligible to board the space flight? I mean, how do you link it to the damages?
This again is a non-performance from her side by not by not informing the medical professionals and Solar Dream about her chronic headaches. This is a
I take
non.
granted.
Council,
Yeah, sorry.
sorry,
No,
just
please
a,
continue.
just a
Yeah.
question. Why was the flight cancelled prematurely?
The spacecraft was cancelled prematurely due to because everybody had caught COVID and no one, everybody was not feeling well. All the passengers were not doing good, so it
Okay.
was one of the
No.
best decisions to come.
Okay, that's clear. Now, how the non-disclosure is relevant to the reason why the flight was cancelled?
Your ladyship, as
To be more specific,
when
how the non-disclosure of chronic headache have resulted in prematurely cancelling, where you mentioned it was due to the COVID infection.
Your ladyship, during the 2 week quarantine, the second week she had started suffering from debilitating headaches. So this she was not in the headaches the whole time, and it just had started during the second week, and they were quarantining for COVID. So it can be understood that she knows that they are in quarantine for COVID, and we also know that headaches is a symptom of COVID. So it is you can reasonably foresee that the headache might be because of COVID, and she should have informed the Solar Dream officials that she's suffering from headaches. So
Okay, that's clear. So you're referring now to the later non-disclosure before the launch of the changing circumstances as opposed to the chronic headache condition. Am I right?
yes, yes, yes.
Thank you.
Can I continue with my submission?
Please proceed.
Her actions clearly intended an attempt to hide the material facts, that is, her chronic headaches, as she was scared, and she would fall short of the eligibility criteria, as intended in 3 paragraphs within the book problem. First, when there was a medical evaluation done to check her eligibility in paragraph 8, and then during the quarantine time, during the second week, where she was having debilitating headaches, and then when they had a medical evaluation with the nurse right before the launch, she not nowhere did she mention anything about her headaches, let it be the chronic headaches or the headache during the second week of quarantine. Miss Astrothia's failure to report her headaches, a critical omission, significantly hindered the spacecraft operator's ability to manage health and safety. Miss Astrothia's failure to fulfill her contractual obligation constitutes a breach under the agreement, resulting in losses for Solar. Section 109 of Contract Law 2004 states that any non-performance gives the aggrieved party a right to damages either exclusively or in conjunction with any other remedies, except when the non-performance is excused under this law. Ms. Astrothea is liable to Solargene for damages as stated as stated above, as she has not performed her obligations as per the contract. Nor does contract or any of these scenarios fall within the exceptions. Moreover, under Article 110 of the Contract Act 2004, it was stated that the aggrieved party is entitled to full compensation for harm sustained as a result of the non-performance. Such harm includes both any loss which it suffered and any gain for it was deprived, taking into account any gain or aggrieved party resulting from its avoidance. Ms. Artemis is liable for full compensation Miss Atramis is liable for full compensation to Solar Dream, accounting for both the losses incurred. If Solar Dream had known about Astro 3's chronic headaches, Solar Dream would have treated her independently of the other passengers, as chronic headaches are not expected to be normal. But in reality, they weren't even aware of Miss Artemis's suffering of headaches, and because of that, they couldn't take any reasonable steps to the extent to which the harm could have been reduced. Space travel is no small feat. There are numerous procedures and formalities associated with it to ensure a safe and successful journey. The omission of such a crucial detail with respect to the medical condition is a grave action committed by Miss Artemis. It was not a mistake, rather an intent to deceive. She was well aware of the fact that it could affect her eligibility and that it would affect her career and that her it would affect her career, which also means she was well aware of the consequences that may follow due to this non-performance. Moving on to my second submission, the second leg of my argument is Miss Astrothea has committed fraud by concealing facts. Miss Astrothea is liable for breach of contract as she did not disclose all the facts material to the formation of contract and therefore amounting to fraud. It is stated under Section 40 of the Contract Act 2004 that a party may avoid the contract when it has been led to conclude the contract by the other party's fraudulent representation, including language or practices or fraudulent non-disclosure of circumstances, which the latter party ought reasonably to have disclosed. Clause 5 of the agreement highlights the necessary medical evaluation required for the passengers to travel to outer space. In this instance, Artemis' omission of information that was essential to establish a contract has amounted to fraud. Moreover, she had concealed the fact to deceive the spaceflight operators.
Right.
With regard,
Uh, Council, just a second here. So you're referring to Article 40 fraud, which allows the non defrauding party from avoiding the contract. Now, in this case, I believe there is no instance that one party either means your client is not seeking itself to absolve itself from its obligations. The contract has been performed in part, and now it's anyway become a bit infructuous because the flight has returned, right? So, what impact Section 40 or Article 40 has on this fact? Because now the flight has returned, there is nothing capable of being performed now. So, whether it's fraud or not, that is immaterial.
Your Lordship, but it is still a breach of contract and it can be connected to the damages of.
It can be, but that's not the wording of this particular section that you cited. It says party may avoid the contract, right? Which kind of alludes to there's a fraud. The other non-defrauding party can say I'm not performing. I'm absolved of my obligations, so nobody can sue me later, right? But the way it is worded here does not link it to the right to claim damages in itself. So you're using this provision, so I just want to be sure that how it is going to help you with your counterclaim.
And just to add to that, counsel, if you could please help me with the elements of fraud.
Um, the council will get back to the questions at the rebuttals, during the rebuttals.
You can continue. I have to apologize. It seems my timer was stopped when the rounds had started again. So I'm not monitoring for this particular round, this particular session. So if anyone is monitoring and can help with the time, that would be good.
I believe it was in Dubai time 12:47 when this started, so probably we are past the time. Yeah.
So
So
counsel, I would
11.
ask you to conclude, please.
Yeah.
Yes, I'm not sure. To conclude, the council seeks that the counterclaim stands and Mr. Astrosia is liable for damages to Solar Dream for breach of contract. It is an
Okay.
honor, it is a pleasure arguing in this court.
Thank you.
Thank you.
I
Defense to
apologize.
counterclaim can proceed.
Yes, ma'am. I apologize for the confusion that happened. May I start?
Yes.
Uh, I'll first begin to answer Your Honor's doubt regarding the damages. As far as the claimant is concerned, in this case, damages are two types. It's either actual damages or constructive damages. In this case, we are concerning the damages for lost opportunity. For this, we have two cases to cite. First is Gates versus City Mutual Life, and second is Malik versus JC Hutton. In both the cases, it was stated that when there is a representation is made and due to the other party's negligence, there is a loss of opportunity that we have suffered, and there is a causal link between the two. That is, due to Solar Dream's conduct, we suffered a loss of opportunity that was known to us. The sales representative, as per the representations made, we knew that there is an opportunity that we could have gained sales and some amount of more better profit we could have attained. Due to this, we are claiming damages that is 7.5 millions, including other things.
Continue, proceed.
I'll begin with my first argument regarding the counterclaim. So, the failure to disclose the headache during the medical evaluation process cannot be counted as a breach of contract since they are excluded from the contract's requirement. The clause 5.2 is applicable only in the case condition when the illness is capable of affecting the passenger's fitness for the space flight. In this regard, the illness was persisted for the last 5 years and is part of her daily life. It never impaired Artemis's daily activities or her ability to do any function. In reference to clause 5.3 and 5.5, which involves changes in the medical condition, first, this also includes the medical condition's ability to affect the passenger, which cannot be said to be the case in this scenario. Secondly, there was no substantial change that needed to be reported since it is a matter of headaches, and headaches can sometimes increase in intensity and decrease in
Counsel?
intensity. Yes, ma'am.
I'm sorry to interrupt you. Just I want everyone to be clear. Are we talking about the earlier disclosure at the beginning of the contract, or are we talking about the non-disclosure before the launch?
Ma'am, we are talking about both the non-disclosures because our client, that is Artemis, this was a part of her one whole. That is the problem of headaches. So the headaches continued, and since they are continuing for the 5 years, though, both the non-disclosures are part of the singular problem of headaches.
Oh, okay. It is in your defense that it wasn't in
Yes.
her subjective knowledge and belief. Am I right? Is that your?
Yes.
Okay. How about in the Moot problem in paragraph 8, where the facts suggest that she made no mention of the headaches because she was afraid that she would not be allowed to participate, and then later on not mentioning it before the launch for the same reason she didn't mention it earlier? How do you address that.
For this, we would like to take the defense. That is our third argument. That is, this was done in good faith. It was not a purposive act of omission or concealment on part of Miss Astrothia. She just, on her own belief, thought that the headaches are part of a daily life and did not need to be told to the authorities, because authorities could have taken it at a different intensity that it is. Since they usually provide Artemis with a list of ailments that needed to be written. After more and more treatments from doctor, she had no listed ailment that needed to be written. That's why she made no mention. What was mandated by the contract was she had to disclose in the form of an ailment or a disease or illness. In this regard, headaches did not form part of any illness. They are just part of a daily life where no diagnosed illness was ever told to her.
Thank you. And how about the other symptom of tiredness?
Mom, the tiredness can be attributed because she took a flight. There was quarantine. She had to, before any flight or any, and since there was a space flight, there are a lot of things that needed to be done. She had to travel. The tiredness can be attributed. Tiredness is not a major symptom that can be, since COVID-19 has various symptoms as written in the clarification, only tiredness and headaches that can be part of anyone's daily life, that should not be attributed as a major thing that needed to be reported.
Thank you. Please continue.
I have already stated this third argument, that is the good faith argument, while answering the question. Now I'll proceed with my second argument, that the claimant cannot be held responsible for the cancellation of the space retreat and the reputational harm that is suffered by Solar Dream, and it was due to lack of its own safety protocols as taken by my senior claimant. Solar Dream owed a duty of care to its passengers, including Artemis. The inability of Solar Dream to act quickly and contain the spread of virus amounts to negligence on its part. As per the doctrine of clean hands, a party should be prevented from obtaining relief when the party's wrongful conduct has made it such that granting relief would be against equity and good conscience. Solar Dream, by acting negligently and breaching their own terms.
I'm sorry, counsel. Sorry, you just mentioned the principle equitable interest that applies for equitable reliefs.
Yes.
Are you asking for any? I don't see any equitable reliefs in.
No, Ma'am, this is part of a case that I have cited in my skeleton argument. I am relying on the doctrine of clean hands, that is stating that since Solar Dream is the main party who did negligence and breached their own terms, we are not liable for non-disclosure, because Solar Dream was the main party who conducted negligence.
Okay, thank you for clarifying. Just want to point out that the claim, the counterclaim is claiming contract. So let's proceed on that basis.
Okay. The outcome of the space retreat would not have been changed if Artemis has disclosed her headaches, and she cannot be responsible for the subsequent outbreak. I would also like to point out that in the facts it is written that in the subsequent months, COVID-19 has, this means that COVID-19 has already been there. There was only a new variant that came. This means that Solar Dream had to be prepared for a virus outbreak. Just because Vulcan variant came at a higher intensity does not give them the defense. Lastly, Solar Dreams cannot be held liable for the reputational loss due to their own conduct. Artemis did not directly engage in any act that led to cancellation of reservations. She merely shared the details, which is common among content creators, which cannot inherently damage a company's reputation. The theory of proximate cause states that liability should be attributed to the party whose action directly and immediately leads to the harm in question. In this regard, the disclosure of Artemis cannot be said to be that much related to the eventual loss of reputation that Solar Dream suffered. Due to the above reasons, Ms. Ashrutia cannot be said
I'm
to.
sorry, could you please repeat your point in relation to the loss of reputation? What is it their claim that
It's due to the theory of proximate cause, which states that liability should be attributed to the party whose actions directly and immediately led to the harm in question.
No, my question was about loss of reputation. Was it ever mentioned by the defendants that that in any case is sort of the subject matter under discussion?
It's in the fact sheet that Solar Dream also contended that loss of reputation happened due to Artemis's conduct, even though it is not stated by the defendants in their proposal today. But I have still taken it into consideration and prepared a defense for that.
Okay.
You can
Continue,
proceed.
please proceed.
Okay. I like to submit my argument because I have stated all my arguments, and like to state that and state my prayer that in the DIFC court of first instance, we respectfully pray that Artemis should not be made liable for the breach of contract, and she should be awarded the damages that she has claimed. Thank you.
Thank you, counsel. Rebuttal?
Yes, Your Worship. The Learned Counsel had stated that Ms. Astrothea had done it in good faith, but good faith can be expressed or implied. But in the contract itself, the agreement, it is mentioned that they should explicitly, it was told that explicitly the passengers should tell the medical professionals about their past medical condition or symptoms. So headaches can be a symptom or maybe even a condition. So good faith in this case is not applicable, firstly. Secondly, equitable reliefs, which is the unclean hands doctrine, is not applicable here as well, because it is only applicable on equitable reliefs, which is like special relief, specific relief and injunctions. Thirdly, the Learned Counsel had talked about loss of reputation for the client. In this case, in the Moot problem, it is given in para 16 that it has been made clear that they are only pursuing on the basis of breach of contract, and no slander or no reputational damage is being talked about over here. That concludes my rebuttal.
Counsel, you said the doctrine of clean hands doesn't apply in a contractual claim. Is that your position? It only applies in equitable claims.
Yes, Your Lordship.
Is there any authoritative basis for this legal proposition that if there's a contract, if there's a contract and I don't perform, I can still go and file a claim against you? Means, well, where is this exclusion that you're mentioning that in a contractual claim, doctrine of clean hands will not apply? I just want to understand if there is a legal basis for that, and if there is one, we recognize it. Yeah.
It is in the definition in itself that it is only for equitable reliefs. Your Lordship. So,
And where is that definition stemming from, if I may ask?
one moment.
We can come back to this later. If the claimant is ready with a rebuttal, you can, if you want to address for 30 seconds later, counsel, you can do that. Yeah.
So I'm ready. I may begin. In reference to the good faith point that the defendant pointed out, uh, I would like to state that the good faith argument and the clean hand argument both form part of the persuasive value that has been given. Since there is a lack of clear judgment by the DIFC courts, these both are persuasive in nature. That are added in order to persuade the court in order to understand with more clarity the term explicit that is stated in the agreement that the defendant pointed out. The explicit also means that they had to be an illness that has the possibility of affecting headaches. In this condition does not. There is also a strict interpretation which states that contracts need to be implied strictly. Since after going to various doctors, Artemis still did not know any illness that needs to be written. What she could have written in the list that is provided to her. Headaches form part and parcel of everyone's daily life that anyone could have experienced. these headaches were also part of Artemis's life. That's why she did not write it. Whereas loss of reputation, I understand that in the fact sheet it is written that loss, they are not suing for slander or due to loss of reputation, but since they form part of the fact sheet, we are just stating it in order to increase the side to our arguments.
Apologies for interrupting at the stage of salad buttons, but I just had a question. Are you saying that your client took a medical judgment basis which she did not report the headache?
As far as the facts are considered, for the past 5 years she has been suffering from headaches, and she visited various doctors, and there was no identified illness of headaches. What was the reason behind the headache, she did not know, and that's why, since there was no per se conditions or any illness in medical terms why the headaches were happening, she did not specifically mention it.
Can proceed, counsel, in the interest of time. Yeah.
I'm done with my rebuttals.
Okay. All right. I think that completes the order of the arguments. I unless there's any other agenda, I believe we could excuse.
The right. Okay, sorry. I'm sorry. I confused. I was just looking at the agenda. So the last thing is a junior claimant rebuttal on the agenda.
Yeah. So this was that, right? So
Yes, yes,
yeah,
yes.
yeah. So maybe counsels for both claimant and defendant, we would like to excuse you, and thanks for all your arguments. Uh, Maybe judges, we can hang out here and have a quick
Yes,
chat.
please. Yes, I think there's some problem with the firm's firewall, my firm. So I do not have the link to the judge's room. So the only way we would be able to connect this through this link. So if I could just request the participants to please exit unless any feedback is to be given.
Yesterday, the feedback was given. So, do we expect the feedback in this round also?
I mean, yes, feedback if you require. I think if Bijan or Hiba wants to go first, and then I will join in, or how do we go about the feedback?
Before that, I would just want to interrupt here. So, if the judges want to join the judges' breakout room for a quick discussion, I can paste the link on the chat here.
Please, that would be
Oh,
great.
yes, please, if you can do that.
Yeah,
Yeah, so then in that case, the participants can wait here and the judges can join the link, have the discussion, and get back.
Please,
I'll,
please.
I'll put it on the chat. Thank you.
Thank you.
that's great.
this,
And she's
I'm
like, tell her to
panicking.
answer the question.
Could you please just check with the judges how much more time would it take?
Yes, sure. Give me 5 minutes. I'll check and
Yeah.
yeah. But I would still request you all to have some patience, um, so that we can wait for the judges
Sure,
to
sure.
come
Yeah.
back. Thank you.
Guys, give us 5 minutes.
Hi, guys. You can come back to your systems, turn on your cameras and microphones. All right. So, shall we? I think Hiba will join. Aditya, she needs to
Yes,
send the email, so maybe we
yes,
can start. Yeah.
absolutely. Should I go first? Do you want to go?
Yeah. No, feel free. Yeah. Go ahead. Go ahead.
Right, so guys, a very good job, all of you. The entire point of the moot is to, we will ask you questions and we will try to disrupt the flow. When we are disrupting the flow, we are checking if you have it structured in your mind enough that you can shuffle around the arguments and present them in a convincing manner. So,
Hello.
hi, Heba. Hi. Yes. Should I, yeah, I'll just continue. So when we're doing that, we want to see that you remain confident. And when you remain confident, you can shuffle around and you present it to us in a persuasive manner. And that confidence can come from one practice, which is one of the reasons why, you're doing these moods and will help you in the longer run of the career. And second, knowledge of the facts and the law, because any matter which you're doing, you would have to go through in detail and analyze every single word, and every single word matters. That was that is the general idea behind it. So for all of you, one, have that structure clear in your head. Have the shorter versions, have the longer versions, because I think generally where everyone struggled was shuffling around and managing time when particular questions were asked. So have a shorter version, have a longer version, know when to prepare, how it should all be persuasive. And more importantly, apart from having these versions prepared, you should never at all sort of express any doubt as to what you're just, pushing forward. Because if you're not sure of your own case, then the person in front of you wouldn't be. So that as a general feedback. Apart from that, what else? Mannerisms. Yes, just remain calm, sit back, relax, ensure that the entire full body is visible and that you're focused towards the camera and you're looking at the judges and you're sort of moving around in a very composed manner. Make sure you're not looking anywhere other than the screen, because during this time and when we're doing all these virtual things, it is important that even on the screen interactions, how they seem to the other side is just are just kept in mind. When you're applying legal principles, when you're citing provisions from particular laws, legislations, uh, don't cite the number. Make sure you read the provision, emphasize, modulate your voice to emphasize on particular points in order to summarize, establish elements. You can use hand gestures, one, two, three. Uh, Make sure you're referring to those provisions in substance and not just the number of the provision. When you're referring to a case, first establish the relevance of the case as to how you're gonna apply the facts uh, in your particular matter, how that case is relevant. Your ratio cannot be read without the facts. So that way you sort of build your argument. And apart from, I think that's all from my end. This is general feedback to just help you all, and this is not does not mean that any of you did not perform well in any of these areas. But yeah, I mean, you all did a good job, and this is the first step. Be motivated for all the moods and activities that you do in your life. And, good job.
Yeah.
I
No,
want
I'll concur
to
with
hear me.
Aditya. That was very thorough feedback. Yes, Heba, we can hear you. Means I would just add one more, couple of more things. Is um, it ability to keep calm composure and still kind of coming back to the core argument is the sum and substance of the moot court. So I think, making sure, as Aditya said, have that shorter version in mind. No matter what, you gotta stick to it, come back to it. The other thing is, not get distracted. If we now in the virtual setups, it's easier to be distracted by movement around you. So again, if you guys move to the next stage of competition, do keep in mind, be in a place where there are lesser distractions. Again, there is enough light. The body language is important, the mannerism is important. So make sure that you are in a setup where everything, you're not distracted, and also you can see judges and other your other side, as well as we can see you very well clearly. That's important. Mm, not just in moot court but everywhere else. So those are the couple of points. Yeah.
Yeah, I would like to add. So first of all, I was impressed by the junior counsel of the claimant, how she remained composed with all the difficult interruptions from the judges, and this happens in real life where judges are difficult. So it's good to be prepared on how to deal with that. She was well composed and handling those with calm and ease. The eye contact. So both senior counsels, you did a great. I mean, well, the claimant senior counsel specifically, I noticed that you used your notes with discretion. So you were glancing, but looking at the camera, speaking to the judges, which was great. Something to keep in mind when you're delivering your advocacy. You always want to keep that engagement and eye contact rather than reading a script. So well done on that for the claimant senior counsel. And also the other thing I want to know as a learning, this is not for all of you, but sometimes the judges asked threw you off the cliff with questions that you were not prepared for. So in these cases, you would want to, again, remain calm, right? Remain calm. Answer if you know the answer, especially if it's a yes or no question. First say yes or no and then elaborate. And at the same time, if you don't know the answer and it happens, right? Instead of rambling, it's better if you actually admit it, right? You would say, for example, apologies. I don't recall right now. I hope for your understanding. I can come back on this point afterwards or something. And then that would kind of make you move on and not being stuck there when this happens. And the other thing as well I wanted to point out is the use of facts. You use the facts in the maximum advantage, right? So for example, something like the tiredness and the headache, everyone was focusing so much on the chronic headache. But what was really relevant, what was really important is what caused the delay, what caused the cancellation of the trip. So the causation link here is relevant to the symptoms of the virus, not the, so failure to disclose the chronic headache does not directly result in canceling the trip. But perhaps if she would have disclosed this, the defendant could have postponed the trip or took action based on those symptoms, especially the tiredness, which wasn't only headache. But I have to say that the junior counsel of the claimant also addressed this point very well when they were asked in relation to this did not occur to her that it's attributable to that because it's a usual symptom. But the defendant could have used this point in their favor. They did use it, but they didn't emphasize on it well. They focused more on the chronic headache. So keep that in mind, how to use facts to make your legal points. Sometimes facts that, show the other party screw up, but do not go into the legal point doesn't really help. But generally, I saw from both sides very creative arguments. Like you were creative in your arguments and explanations. So well done on that as well.
Thank you so much for the feedback. Thank you so much, everyone.
Thank you so much.
Should we leave?
Thank you, guys. It was great judging your rounds. Thank you, Vision. Thank you, Heba. And hopefully, see you guys in person one day.
Sure.
I may be coming
Thanks,
to
Aryan.
the Dubai arbitration week this November. So if I'm there, I'll drop an email.
Yeah, hit me up. Yeah, sure. And all the
Absolutely.
best participants for this competition for the next round.
Thank you. All the best and good luck.
All the best for your careers as well, the
Yeah.
buds. Good luck. Bye bye.
Thank you so
Bye
much.
bye. Bye bye.
Thank you.
Thank you.